Good to have you here. We're delighted to be gathering today to announce the introduction of the Fair Employment Protection Act. And I want to make a few introductory comments and then share the podium with my colleagues here. You know, in the 21st century, harassment and hostile work environments should never impede an individual's capacity to achieve economic success. If you work hard and you play by the rules, you ought to be able to get ahead. Unfortunately, workplace harassment remains an unacceptable reality, and it harms the economic security of too many people, including a significant percentage of women. A decision by the Supreme Court of the United States in the case of Vance versus Ball State University last June really set us back significantly in terms of the ability that individuals have to make a case against harassment in the workplace, hostile work environments, and discrimination in the workplace. The decision dealt with the harassment that was experienced by Ms. Vance by a supervisor. And as she sought to achieve justice, the Supreme Court basically ruled that if the supervisor didn't have hiring or firing authority, that they weren't really a supervisor, even though this person greatly influenced and controlled her work life, set her hours, decided whether or not she would have time off, decided who coworkers might be at a given time. And this is just wrong. This doesn't make any sense. And so I think that the Supreme Court of the United States got the case wrong in Vance. And we now have an opportunity to correct this wrong by introducing and advancing the Fair Employment Protection Act. It's time for Congress to stand up and give workers the tools that they need to level the playing field at work. And it's time for Congress to restore these workplace protections. Everyone should have the chance to go to work without worrying about whether they'll be harassed or have to work and labor in a hostile environment. And everyone deserves a fair shot at economic success. This bill makes it clear that that employers bear some responsibility if their supervisors engage in harassment or create a hostile work environment. And I would say that Congress has stepped in numerous times before when Supreme Court cases have limited or restricted workers' rights and workers' civil rights in particular. You can point, for example, to the Civil Rights Act of 1991 and recently passed the Lilly Ledbetter law that also reversed what I would argue is a wrongly decided Supreme Court case. I want to thank, in absentia, my colleague, Chairman Harkin. I want to thank my former colleagues, George Miller and Rosa DeLauro, for their leadership in the House. I will call on them shortly. I want to recognize the National Women's Law Center and the Leadership Council for Civil and Human Rights for their extraordinary leadership in this effort, and the many organizations that are represented in the audience today that were crucial and instrumental in getting this bill to the point that it is now.